I am pleased to join you for this important conversation on post-election electoral law reform agenda. This conference has assembled practitioners who will add immense value as we think through electoral law reform for the 2022-2027 cycle. I thank the Electoral Law and Governance Institute for Africa, ELGIA, who have collaborated with the Parliamentary Committee on Justice and Legal Affairs and the Independent Electoral and Boundaries Commission to convene this important workshop. I also take note of the participation of other electoral and governance institutions like the State Law Office, the Kenya Law Reforms Commission, Office of the Registrar of Political Parties, Commission of Administrative Justice, among others. The multi-sectoral nature of this workshop is also evident in the presence of vital civil society organizations and religious organizations. I also recognize the development partners, the USAID and the United Kingdom Foreign Commonwealth Development Office, FCDO, for supporting this important consultation. Our rich political history is characterized by the struggle to realize the rule of law, social and economic transformation, and sustainability. Our decades of effort culminated in the Constitution of Kenya 2010, which embodies the spirit and aspirations of Kenyans. As we reflect on the 2022 general elections, participants might recall that election management was a central theme in the struggle for constitutional reform. Indeed, the disputed elections in 2007 defined the constitutional moment that gave the final impetus to the enactment of the Constitution. Allow me to lay the groundwork for some ideas, some which have already been talked about, I consider important for deliberation. At the core of our Constitution are the national values and principles of governance, which both describe and prescribe what Kenya should be and how it should be governed. Patriotism, national unity, sharing and devolution of power, rule of law, democracy, and participation of the people anchor Article 10. They define the Kenyan character. A free and fair electoral process embodies the constitutional sovereignty of the Kenyan people and is the cross-cutting feature that facilitates the ultimate accountability to the people. In this sense, peaceful transition of power and constitutionalism is guaranteed and protected. The 2010 Constitution lays significant importance to both an elaborate state governance structure and an adequately regulated electoral framework as an important element of that governance structure. Further, the Constitution has two broad pillars: nation building and state establishment. Elections and peaceful transition of political power and the quintessential props for these two pillars that contribute to public participation and accountability, thus opening the gates to legitimacy of the state. Whereas the competitive electoral democracies are by their nature divisive, it is important that the aftershocks yield public confidence that in turn services the objectives of nation building. In 2022, Kenya undertook her third general election since the 2010 Constitution. As we move towards the third political transition, we must be aware that how our governance structure and the electoral framework in particular are contributing to the consolidation of constitutional transformation. The notion here is that consolidation of constitutional transformation speaks to the objects, principles, and the social and economic transformation purposes of the 2010 Constitution. In electoral context, therefore, consolidation of constitutional transformation will require that the legal framework, the institutions, and the administrative and operational processes stimulate the necessary efficiency and transparency to inspire public confidence. In the last three elections, we have tested the legal and institutional framework, and I affirm the agenda for constitutional transformation is on course. The IEBC has, despite the perilous nature of elections in Kenya, put its best foot forward in delivering on its mandate to the people of Kenya. There could be an argument there, and you are guaranteed the right to it. Equally, the judiciary has exercised its independence and constitutional authority in elections in providing fundamental landmarks to the growth of our electoral law jurisprudence. We have gained and learned valuable lessons through this journey. Nevertheless, if full consolidation of constitutional transformation is to be realized, we must be honest, there are real challenges that need addressing to make subsequent election cycles trouble-free ones. For this to happen, we require the goodwill and commitment of all stakeholders involved in the electoral process. As government, we know we have a constitutional obligation to collaborate with all stakeholders in any constitutional journey that will benefit all the people of Kenya. Lack of significant challenges to the electoral laws in the 2017 to 2022 election cycle. Though recommendations were made, only late changes through the Political Parties Amendment Act, which were more political than transformative, were affected to the electoral law. The last comprehensive review of electoral law was in 2016 by the Joint Committee led by Governor James Orengo and the former Governor Kiraitu Murungi while serving in the Senate. The changes directly impacted the 2017 election and largely influenced the Supreme Court's decision in the incidental presidential election petition, Raila 2. I am of the view that given the dynamic nature of Kenya's political and socio-economic landscape, it is necessary that discussions on the electoral law reforms should begin immediately and that enactment of necessary electoral laws be done at least 12 months before the 2027 elections. And this is so critical because even as we speak, I don't know how the team will tackle this, because we also have cases. People are actually challenging the validity of the census numbers. And those matters are in court. And if it happens that those censuses are declared invalid or they get their way on their petition, then what does that mean for the process that is going on and where we are going? Because then it would mean that everything again is put to hold unless we can all say that we have clean data around the census. So that is a landmine somewhere in the path of this bipartisan talks. In Kenya, the Constitution allows citizens to discuss anything as long as you do not fall afoul of the same Constitution. For instance, you must always play by edict that your freedom and rights end where mine begin. Therefore, we must have a structured negotiation before you proceed to violate my freedom and rights. That understanding must be ingrained in us, that whatever we do not have a carte blanche in matters, rights, and freedoms. This is why I invite this conference and other Kenyans to apply their minds to the following matters on the governance architecture of our country. First, accountability of the executive. An executive that is neither appointed from, hosted in, or derives indirect agency from the legislature, as established in our Constitution, poses unique challenges. The seemingly absolute exclusion of the executive from Parliament begets an unintended accountability deficit, which at present is only bridged by reducing the gaping information hole in the running of government. Whereas the Constitution leans towards absolute separation of powers, it may be necessary to to mitigate the drastic consequences of the accountability deficit between the two institutions by providing channels for checks. His Excellency the President has expressed his views on the subject, which views indicate the true and uncontested position of the Kenya Kwanza government. Indeed, Honorable Kalonzo has underpinned that particular item. Second, executive and parliament collaboration. We will continue to collaborate with the two houses of parliament to ensure that the members of cabinet to whom the people of Kenya have donated their sovereign power remain answerable and accountable to the country through our elected representatives. The State Department for Parliamentary Affairs in my office is holding brief as a bridge between the executive and parliament. We believe that this initiative does not derogate but reinforces fundamental constitutional principles. Preliminary indications are that this experiment is working quite well in ensuring the executive does not lag behind on parliament expectations. Third, the balance of power between the two houses of the legislature. This remains an area of frequent controversy. Whereas both houses derive their mandate through direct election by the people, there remains a subsisting imbalance between the powers of the two houses. This sprouts into frequent sibling rivalry, which defeats and counteracts the objects of the creation of the two houses by the people of Kenya through the 2010 Constitution. Notably, the Senate, as currently established, is not a house for reconsideration of legislative proposals. Rather, Senate has the mandate over limited legislation concerning the county governments. We have an opportunity to consider whether Senate should not be a proper upper house, given it derives its power from the direct elections similar to the National Assembly. Settling this will lead to the harmonization of duties of the two houses for the benefit of the constitutional development. And we are beginning to see quite a number of challenges between those two houses. So that's an area that we need to really focus on. The fourth item is implementation of the two-thirds gender principle. The Constitution expressly provides for the enactment of legislation towards the realization of the two-thirds gender principle within 5 years of promulgation. This is despite several court decisions directing Parliament to fulfill this mandate, the Chief Justice's advice to the former President to dissolve Parliament for failure to do so. So for 13 years, the country has struggled to understand the necessity or indeed the relevance of the two-thirds gender principle, constitutional amendments that have been proposed on this matter. Some of the recommendations have had reasonable formula for actualization of the two-thirds gender principle. Unfortunately, some recommendations have notoriously been at the expense of preserving the structure and composition of the legislature as prescribed by the Constitution. So, as we move forward, and Mheshimiwa Kalonzo and others are at the center of this, we intend to take another crack at this again. Through progressive dialogue such as today, we should find reasonable solutions to this constitutional challenge. Fifth, the nagging issue of capacity for devolved units to facilitate constructive accountability. Devolution remains one of the transformative elements of our Constitution. In the early days of devolution, the separation of the county executives from the county assembly seemed a novel idea until it began to show misalignment of power and interests. This led to the current controversies, only resolved through impeachment. If we are thinking constitutional realignment, it is important to consider options which may facilitate constructive institutional checks within counties. Then there's the issue of election management. Parliament has made significant progress establishing the legislative framework contemplated by the 2010 Constitution and the establishment of relevant institutions to fulfill the constitutional objects on elections. Over the last 3 elections, the electoral bodies built capacity and operational efficiency in management of elections. On future election cycles, the conversation beginning today should address the following issues, and you have touched on them, but there's no harm in repeating them. The absence of a properly constituted electoral commission poses a constitutional risk to our democracy. The immediate worry is that the commission will lag behind in preparing for the 2027 elections. Cumulatively, delay will slow progress in the constitutionally mandatory boundaries delimitation, preparation for the mass voter registration process, therefore a new voter register considering the delimitation, and general preparedness for the 2027 election. As such, conversation in this conference should complement any other processes in place, including the National Dialogue Committee, NADOC, and the process for recruitment of new commissioners. You should provide concrete recommendations. I want to assure you that I'm in full support, and the government is in full support, of successful conclusion of the bipartisan discussions or conversations that are taking place in Parliament today. We want to see something positive come out of it, and we'll go out of our way to make sure that we also see some positivity through that process. We have a country to defend, to protect, to live in, so we have no intention of walking away from that particular responsibility. The second thing which I just want to highlight is that over and above this, and as we look at the elections and we do the review, sooner or later, we are also going to make public a draft bill so that there can also be proper public participation and dialogue around it on the issue of transition of executive authority. Because what we have is simply the assumption of office bill, which basically just deals with the ceremony at the end of the day. A committee is set up, they prepare, and they're just preparing for the swearing in of the elected president, and then it's basically done. But transition, and even as you talk of transition in this conversation, transition is beyond assumption of office. We want Kenyans to go further and make sure that transition is not just at the helm. What are the components that need to be dealt with for smooth transition of executive authority? In the last election, we saw things that we have never seen before. As much as we may raise issues about IEBC, but we also saw things that we never saw before from the political class. We were witnessing things at Bomas that have never been witnessed at all. We came across situations where even public officers who under the law are supposed to do something were not doing it. Even a government printer refusing to print to gazette the results of an election. The IEBC issuing their certificate and expecting the government printer to do what they are supposed to do. The government printer was not doing it because presumably waiting for instructions from another corner. That could have plunged the country into a crisis. We were seeing gazette notices of the outgoing president appointing people after he has vacated office. Seeing ministers appointing people way after a new government has gone in. So somebody somewhere was hiding gazette notices to make sure that these don't come out. So there are a lot of issues that need to be dealt with so that Kenyans can heal. Because we are talking too much on one side, but we are forgetting that there were people there. And we must also make it clear to the people that the commissioners do not vote. It is the people who vote, not the commissioners. So we must also get away from this fallacy of saying that I had 4 commissioners and you had 3, or I had 3 and you had 4. They are not the ones who vote. It is the citizen, the ordinary citizen of Kenya who casts the vote, and that is how it goes. It's good for us to look at these things in totality, but more important, we need to ask ourselves fundamental questions. How should ministers behave during the transition of authority? How should PSS behave? How should the person who is supposed to do a statutory duty or constitutional responsibility, how should they behave? What kind of expenditure should we be looking at? There's the famous Article 223. How do you balance the management of that article within the Constitution without paralyzing the operations of government, but at the same time, so that you make sure that an outgoing government is not engaging in a scorched earth policy of literally plugging everything out of the coffers so that the next government is set up to difficulty. So these are some of the issues, depending on which side of the fence you sit. But at the end of the day, these are very practical issues that will need to be delved into. And I'm sure with the kind of leadership that we have in the committee, I'm sure with an open mind, our teams there can give us a unified position, harmonized position that will be healthy for the country. So there's a lot of burden on Kalonzo's shoulders, the way it was when he was foreign minister. That burden has come back.